Thanks so much, Sean. So what we've chosen to do in organizing this panel, we thought we'd try to have a lively conversation at this late point in the proceedings rather than a set of presentations. So we're going to go through some rounds of questions here. I wanted to note that, of course, our speakers' biographies are available online in the materials, and you see their titles here. I wanted to say a couple things about the speakers, whom I all respect very much. Vicky Cundiff is a bet the company lawyer in the field of trade secrets, and she also teaches at both Penn and Yale law schools, and is a leader in the trade secret law community. So it's really a privilege to have Vicky here with us, and I appreciate her taking her time from her very busy schedule to join us. Dr. Nicola Searle is a recognized scholar in this field. She has written some very important work in trade secrets, and she's been engaged by the UK government to do some national studies on intellectual property law, and has been invited by WIPO to speak on this topic. And John Hoganson is currently at AMD. Before that time, he was at Micron, and Micron has had a famous battle to try to protect its trade secrets across three or more countries. And John was instrumental in convincing the government, the U.S. government, to impose some national security sanctions on Micron's opponent in that case. And I think that is a particularly unique achievement, and he has a unique perspective both with respect to the semiconductor industry in which he's been involved, and these pretty epic trade secret battles in which he has observed and participated. So the purpose of this panel is to consider the reasons for and impact of stronger trade secret laws. We've been talking about intellectual property on the wane, and trade secrets seems to be a potential exception. Although it's a more complicated story than that, but certainly in recent years, globally, we've seen stronger trade secret laws. Policymakers and businesses have taken a tremendous interest in trade secrecy, and the European Union passed a trade secret directive in 2016, the same week that the U.S. passed the first federal trade secret law, the Defend Trade Secrets Act. So I'd say in terms of law on the books, trade secrets is certainly waxing, and we see similar efforts we've seen similar efforts in Taiwan, China, partly as part of the Phase 1 trade agreement during the trade dispute with the Trump administration. China strengthened its laws on the books. On the other hand, one might say that trade secrets have never been under such threat because as businesses have digitized their information, what was probably once a corpus of knowledge that would have filled many file rooms and could not be easily stolen, now can be uploaded by an employee to a Dropbox file or attached to an email. So trade secrets are harder to protect than they once were. So it's a somewhat complex story, but it's certainly a story that differs from some of the other IP rights that have been longer established, and the legislative battle has been somewhat different in this instance. So we have a set of questions here we're going to ask, and I'm just going to go down the line, and I'm going to start with the first one. Why are trade secrets important to businesses? How has their importance increased in recent years? Vicki?
Well, thank you, Mark, and thank you for the conference and for inviting us all to participate. So trade secrets have been important in the United States really since before the founding of the United States, at a time when the colonies were certainly accused of having taken trade secrets from Great Britain. And there's been a steady development of trade secrets law over the decades, centuries since then. The classic trade secret that people talk about in the US and perhaps the world over, the Coca-Cola formula, is interesting and also doesn't really tell the whole picture, because I think what we get from the Coca-Cola formula is, gee, it's something that's been able to be maintained as protectable for far longer than would be possible under patent law, and indeed, if it were subject to copyright, even the copyright would have expired. But the Coca-Cola formula is highly unusual, and I think not representative of a lot of the kinds of information that can be protected as trade secrets. And in thinking about this, I was thinking about what are the phases in the life cycle of a company in which trade secrets are important. And certainly one stage is the early stages of the country, the nation stage. You're developing. You don't have a full idea yet of how to solve a particular problem successfully. So you're poking around, and you've got trial and error, and you're devoting research and development to trying to come up with things and then refining it and trying again and trying again. So it may be too early to even be thinking about getting a patent. But you are thinking about getting investors, and you are thinking about getting people to help you advance the ball. And so when you're talking to investors, you've got the classic Arrow's paradox. The investor wants to know what you have, so they're not going to invest otherwise, but you can't show exactly what you have without, and so we've had some recent cases here where investors have been trying to kick the tires on trade secret IP and have later been bitten, saying, hey, you saw our trade secret, and then you invested in another company that was developing something similar. So there's the early stage of development where protecting information before it's really been fully worked out is important. And we've got a lot of nascent industries now, particularly one that's gotten a lot of press here is autonomous vehicles, but there are many others that in the early stages, you need trade secret protection. And then looking at the end of the life cycle of products, you've got the very mature industries. So there may be many competitors in a field. There may be, the patents may have expired. There may be a lot of knowledge. But developing efficiencies to help you produce goods more efficiently, more cheaply. Some of that surplus is shared with consumers. Some of it is plowed into new research for new products. So at that end, it's important. And in the middle, trade secrets are the oil of commercialization. Most companies these days can't do everything themselves, so they're going to be sharing with others in the supply chain or with others, for example, in the autonomous vehicle field. They're going to be needing to talk to people in the communications industry and share information. And as Mark Lemley has famously written, one of the paradoxes of trade secrets law is it helps us share information. So all of those areas are reasons that we protect trade secrets in a whole host of industries.
Thanks,
Stop
Vicki.
here.
Yeah, so John, the importance of trade secrets to businesses, particularly in your industry, and how has their importance increased in recent years?
Sure, thank you. Thank you for having me. We're 3 years into COVID. It's still weird to see people, so thank you all for being here. And Mark's right. I was at Micron before this and have sort of the battle scars of going through a pretty significant trade secrets litigation. I do want to couch sort of, as I have my remarks here, I'm an AMD now, but I'm trying to talk about sort of the industry as a whole. So some of my comments will be on past experience, some on what AMD, but trying to couch it sort of as a semiconductor industry as a whole. When I started in this industry a decade or so ago, no one knew what a semiconductor is. And suddenly, after the chip shortage and everything else, we're one of the most interesting industries in DC at least. We really are a trade secret industry. What we do, trade secrets are critical to everything that we do. It's an incredibly complicated process to manufacture our chips. There's over 1,000 process steps, and they really can't be reverse engineered. So that becomes the secret sauce. So some of these chips are taking, 30 days to 4 months to manufacture. So when you're thinking about the chip shortage, it's an incredibly complex and incredibly labor-intensive, machine labor-intensive, process that comes down to it. And the trade secret is that critical ingredient. So if you think about a patent, the patent is just sort of a recipe or sort of descriptor of what you know. The trade secret becomes how you put it together. So if you think about the challenge around what the United States is facing with a Chinese perspective, Chinese has spent $100+ billion in trying to develop a semiconductor industry, but they have not been successful in putting those pieces together. That's where the trade secrets come together. That's where the trade secrets become important. It's that recipe that goes forward. The industry itself has been driven by Moore's law. So it's been kind of identified as a technology law, but it's really an economic law. It's every 18 months, the number of transistors on the wafer will double. That is the argument. In order to achieve that, every 12 to 18 months, you are refining your process. There isn't time to file for patents. There isn't time to examine that. But more importantly, if you were to give that in a patent situation, you'd be giving your competitor the ability to understand that. So, fundamentally, what you do, you can buy the pieces, but you can't buy the technology. And that's where the trade secrets come into play. If you think about where we're going as an industry, we're going from a place where the machines were making just a single chip to now we're starting to look at things like 3D technology, so stacking chips on top of each other. Chiplet technology, so taking, this is an area where AMD is an innovator, taking many chips, putting them together on a single die so you can make a purpose-built chip or something that is more effective in that way. How you put those pieces together, how those things are all added, all of that becomes the secret sauce that is held together by trade secrets. And as we think about an incredibly complicated, diverse supply chain, you're bringing in many different players from many different companies, and trying to protect them and isolate that becomes incredibly challenging. There's thousands of people involved in this process. So again, it's not one person that knows that, but you start to see a larger challenge in getting that knowledge. So if you look at backing up to and I think this is well known in the industry, but if you look at the Micron case, what happened there, they had not, one engineer go, but hundreds of engineers that went to another company and with them took not only the files, but the know-how, how to put those pieces together fundamentally. So, from a semiconductor industry perspective, the trade secret, that know-how is incredibly critical.
Thank you. Nicola, the importance of trade secrets.
Yeah, thank you. Well, first of all, the obvious thank you very much for the invitation and to the organizers. I don't think I'd been on a GMU campus for about 20 years. I was last here for an Enrique Iglesias concert in the 90s. So not quite the same setting, but delighted to be here. So I thought I'd talk about why, the question is why are trade secrets important? But I'd also want to say, why are they becoming more important? And reflect on what that is in the economics literature, so what's been happening. Economists discovered trade secrets around 20 years, you'll be pleased to know. Some of the information that came out of that was we went from the 1996 TRIPS agreement, started looking more at patents, and then lo and behold, oh wow, trade secrets exist. One of the key papers in this area was published in 2001, and that was based on one of the surveys critiqued earlier in the first session. But we have this idea that trade secrets are actually way more important than we'd realized, and are part of a firm's innovation appropriation strategy that had been underlooked at. And therefore, we need to be looking at them more, which I'm pleased to say, I think 20 years later, we're finally actually properly doing. So just from a research perspective, trade secrets are finally really important. We have major troubles in actually understanding trade secrets. So the survey mentioned before is kind of the gold standard, but we've actually had a lot of trouble developing empirics in this area. Again, in the first session, we talked about response rates. Response rates in surveys for trade secrets are even worse. We have findings in sort of theoretical models that are all over the place. So there isn't yet a comprehensive understanding in the economics literature of why trade secrets are important and how they're being used. It's still emerging. So that was kind of an overview of where we are in terms of the economic approach to it and understanding. Then I'll go into the 3 points of what we do say in economics, which I think are fairly consistent. And I say that's in economics, but I think these are also generally in keeping with what is understood in practice. Correct me if I'm wrong. That's one of the wonderful things about conferences like this, is that interaction between the sort of theoretical side and the practice. So one of the key framings of trade secrets is the idea of disclosure. So the Arrow's information paradox, which Victoria mentioned, was the idea that if you disclose your information, if you disclose your innovation, you also compromise it to a degree. But you need to disclose it in terms of being able to sell things to your consumers. However, disclosing information gives your competitors more information. It decreases information asymmetry. So companies seek to reduce that disclosure by using trade secrets. And one classic, of course, implication of the fact that we recognize the right to disclose, so we have the patent system recognizing the right to disclose, we are also implicitly recognizing the right to not disclose. So we have this balance between the two of trade secrecy as a means to not disclose an innovation but still protect it, and patent as a way of disclosing it but protecting it. And the company needs to decide, in terms of information asymmetry, which approach they prefer. And that's kind of where we spend a lot of time debating on where it's appropriate. It likely varies from industry to industry. We've seen that in patents. So we're still kind of trying to understand what that actually means. The second point that I think is really useful about trade secrets from both a policy perspective and from a firm's perspective is that it fills the gaps, right? So one of the things we've been talking about, well, obviously we've been talking about innovation this whole conference, but there's also a wider discussion about what innovation is, and moving from just the product and process innovations we've been discussing, but kind of more to the marketing and organizational innovation. So when we think of innovation as a much wider concept, and clearly the copyright discussion kind of starts to talk about that, trade secrets address that in a way that other types of IP aren't. So patents aren't addressing marketing and organizational innovations in the same way that trade secrets can. So it really fills in that gap, which is important for the incentive to innovate argument of trade secrets, of IP. It covers the larger scope, the larger subject matter, the inventive step doesn't apply here. So we have a really useful tool that's filling in all the gaps in policy that would be really difficult to address more specifically. And the third point is going back to Arrow's information paradox, which you've already mentioned, but the other point of, the fact that trade secrets are enabling that sharing of information, but also performing a really important reduction in costs. So without trade secrets, firms would be forced to protect their trade secrets, so come up with the idea of a factual secrecy, which is what Sharon Sandine and Tanya Aplin have been discussing recently, is the idea that factual secrecy is one thing, but if you had to actually protect every single trade secret and lock it down, it would be hugely expensive for businesses. So trade secrets is one way, again, of implementing a policy that allows for some cost savings to firms. So I think there's many reasons we like trade secrets. We still need to understand them a lot more.
Thank you so much. Our next question is, how have trade secrets become more vulnerable in recent years? Vicki?
Well, certainly you mentioned one of the key points, which is increased digitization. I think when I was starting practice, people said you mustn't ever digitize any trade secret. And we've all heard the stories of the Coca-Cola formula being locked in the safe, and only 2 or 3 people know the combination to the safe. But increasingly, that's not how many organizations share their most valuable information, although I understand that Linus Torvald still says, if you want to keep it really secret, write it down on a piece of paper and don't share the paper. But in any event, digitization certainly enables lots and lots of data to be spirited away from an organization into the cloud in ways that were inconceivable before. Related to digitization is increased supply chain sharing of information. It's great that trade secrets law facilitates sharing, but if the information is shared with somebody else and they're not taking the same kinds of precautions as the trade secret owner is to protect it, then it's potentially compromised. But we do have to deal with the point that Nicola mentioned, which is, well, do we want to turn every piece of information sharing into Fort Knox? And the answer is probably not. So how do we balance the need for tight physical protection with an understanding that this information is yours to use for particular purposes and not more? But there's more sharing going on and more digitization.
Thanks. John, vulnerabilities?
Sure. I maybe should have started here, but just talk quickly about the steps in semiconductor manufacturing, and I think it's relevant in terms of the global footprint here and all the vulnerabilities that happen there. If you think about semiconductor manufacturing, like I said, there's many steps in the process, but fundamentally it comes down to creating, designing, and building. So the first step is you have to really come up with a concept. What do you want to build? Second, you have to design that process, and then you have to go manufacture that process, and then you have to package it and distribute it. So each one of those steps is incredibly intense, obviously, but there are also opportunities for vulnerability. So if you think about a company like an Intel or a Micron or an AMD, we're doing research globally. A lot of that is digital. And you're finding engineers that are all over the world. We often do what are called acqui-hires. So we're buying entire companies in order to get that skill set to bring them into the company, right? So they're on the research side of things. And then if you are then manufacturing, in the steps of the process for manufacturing, there is the front-end manufacturing, so the wafer fabrication. So Micron has a facility in Manassas, 35 miles from here. They're doing front-end manufacturing from there. So they're making that actual wafer. But when that wafer is done, it then needs to be sent someplace, cut up, and put into packaging so it can ultimately go into a phone or your camera or wherever it's going at the end of the day. These products are physically moving all over the world, and increasingly they're not done by one company. They're done by many different players. So if you look at a company like AMD, NVIDIA, Qualcomm, we are all fabless manufacturers, so we're doing all the design work. Then we're partnering with the manufacturer to do the front-end work. That might be a TSMC in Taiwan, or a Global Foundries in upstate New York, or Samsung to do that work. And then they're taking that product and then they're sending it for the back end, so that they're just doing the wafer processing, and they are then putting that together. Each one of those steps, again, there are many people involved, many different machines and different technologies, and how you put those pieces all together, most of that is all trade secreted at the end of the day. So the products are moving all over the world, touching many different people. So there's your first threat. The second challenge is around nation states, right? As these technology becomes so important to the lifeblood of an economy. If you look at what's happening in Ukraine with Russia, right? Russia's inability to get technology because they're being cut off from that is clearly impeding their war effort overall. These are becoming national security issues, so nation states are trying to figure out how to keep up, or at least how to have some capacity in the space to manufacture these things. So you're not only facing as a company your competitor, you're facing entire nation-state apparatuses, particularly intelligence services that are embedding themselves into this, all trying to get this technology at the end of the day. So what you're seeing is, as the intensity of the knowledge base, the intensity of the trade secrets are increasing, you're also seeing a really concerted effort to pull that all together, to extract that talent, to extract that know-how. And so it's challenging.
Yes,
Yes.
certainly a level of challenge greater than just an employee walking out with your customer list.
Right. Yeah, I mean, I would say, though, you hear like one customer leaves or one employee leaves, it's not a big deal. You say it's one person. If it's a senior manager, maybe it's a big deal. But if you have 100 of those people go, you start to see this quickly, what the pattern is, and your ability to understand that and recognize and respond to it quickly is essential.
Wow.
So.
Yeah. Nicola?
So I have a slightly different take in that I think what we are talking about is that the perception of the risk of vulnerability has increased rather than actually being able to say that the vulnerability has increased. with two caveats to that. One is that's really hard to measure, so it's a bit of a cheap dig, saying, we can't actually prove either way because it's really difficult to measure how vulnerable things are because, of course, trade secret from a quantitative perspective is very difficult to do. And the other reason that's a bit of a cheap dig is that actually doesn't really matter, because even if there isn't an increased risk, it's still going to affect how firms behave. So, does it actually matter that the perception of the risk may not actually reflect the actual risk? But I was thinking about sort of the three sort of risks that there are. So we have the misappropriation risk, which we've just talked about a bit, the litigation risk, which we also talked about a little bit in the first, and then kind of the reverse engineering, which we haven't really talked about so much. So the misappropriation, sort of the idea of theft, the idea of knowledge leakage, depending on how you want to call it, is something that The Economist has been talking about more recently. It is now considered a general business risk of the loss of this knowledge, of the loss of trade secrecy. Economist also referred to the golden era of industrial espionage. So clearly this is something that is perceived as a risk. We have the national security and geopolitics discussion, which we've already touched on, and of course the next panel is on exclusively. So we do have this environment where clearly firms are worried about their trade secrets. But we also have on the labor mobility side, so when we talk about employees, we have increasing precariousness, good word, of employment. So people find themselves moving jobs more than they used to. So you would expect leakage to be higher if people are moving around more. We also have more complex supply chains, as has just been mentioned. And then we haven't really touched on it, although I think we probably will a bit more, is the cybersecurity race, this constant, one-upmanship. It's really a moving target in terms of protecting your trade secret appropriately and making sure that it's protected, both from the legal perspective and reasonable protection, but also from an actual perspective. The other is litigation, which it's a kind of as a vulnerability, but rather than typically when we think about litigation, it's actually how the litigation of that you'll be found to have infringed or somebody else would be infringing. But we do have research suggesting that firms will use trade secret to actually reduce their litigation risk as a whole. So rather than expose the fact that they're working on a specific area and by patenting it, they'll keep it secret. So there's a little bit of a risk there, but it doesn't necessarily mean the trade secret is more vulnerable. And then we have just a general increasing cost to business if we're getting in litigious environments, like the example Victoria gave on kicking the can and then finding yourself in a lawsuit. But the one thing we haven't talked about so much is the reverse engineering. So there is, we've got very fast-moving technology areas. So even if the trade secret is well protected, it might find itself, even if the policy is correct, it might be that the market moves on and other people figure it out very quickly, or reverse engineer it, or independently invent it. So it might not actually matter so much that they're more vulnerable, because that's what's happening. And there's, of course, a hugely well-developed breakdown reverse engineering industry now, so you can have it paid to do all of these things. So, multiple things happening, but I guess the sort of moral of the story is that the perception of the risk of the vulnerability of trade secrets is certainly increasing, and we would expect firms to behave differently, and we would expect to see that reflected in policy.
Thank you so much. So next, let's talk about how has the legal environment changed to address the perceived increased risk or the increased risk, and has it been sufficient? Becky.
Thank you. So picking up on some of Nicola's ideas, again, as the academics in particular know all too well, it's very difficult to do truly good empirical work in this field, but some AIPLA did a study on costs of trade secret litigation, and it appears that in general, trade secret litigation costs more in relation to the amount at suit than other kinds of IP litigation, including patent litigation, because you're not only talking about the thing itself, the idea or whatever it is that's being protected, but you're also having to go very deeply into historical facts in terms of what happened, who had access to it, why did it transfer, was there independent development going on? And that can be a very expensive exercise to figure out. So that's a risk of litigation, and I will tell you, as in patent litigation, the risk is you're suing on your patent, and at the end of the day, your patent is invalidated. Well, in trade secrets cases, at the end of the day, a risk is that, as in one recent 10th Circuit decision, the court says it's not a trade secret and then prints it in its entirety in the decision. So litigation can itself be a risk. How is law changing to perhaps offer some protections? Well, I don't know if now's the best time to discuss the Defend Trade Secrets Act.
I think so, yeah.
Okay, great. Well, so in the United States, trade secret law has historically, except on the criminal side, been a subject of state law. And it's developed fairly uniformly. You can point to some differences, and in particular cases, they make a difference. But the Federal Circuit some years back said that there was basically a fairly unified view of national trade secret law. The thing is that it was subject to state laws. So as the economy became more global and in trade negotiations, we were working on negotiations on a country-to-country basis. Of course, the question comes up of, hey, you're so keen on trade secrets law, how come you don't have a federal trade secret statute? And that was certainly an impetus for the Defend Trade Secrets Act, which largely built on this sort of common understanding of what's protectable as a trade secret and what are appropriate remedies, but made it a federal statute. What is interesting is, and so that was enacted, as many have noted, in 2016, just about a week ahead of the EU directive, which of course was being discussed in tandem. And what's interesting is that the way the Defend Trade Secrets Act has been interpreted by the trial courts in the United States is that it's been held to have extraterritorial reach if some acts in furtherance of the misappropriation took place in the United States. And that has occasionally been held to be true of state trade secrets law, but not on a consistent basis. And what that means is if these trial court decisions are ultimately affirmed by a circuit court, what this means is that if there's misappropriation that begins in Malaysia, as was true in one of the leading cases in this field, results in dissemination of trade secrets to other countries to manufacture products which are then distributed throughout the world. But some acts in furtherance of that whole exercise, namely access to servers and some meetings, took place in the United States, that U.S. courts may have jurisdiction over that misappropriation. And that's something that has not reliably been true in the case and is very important in the increasingly global dialogue about misappropriation. And what that means is that U.S. courts can compel testimony from abroad and ultimately issue worldwide remedies. Now, the remedies are, of course, subject to treaty obligations, and it's not such an easy thing that a court in the Northern District of California issues an injunction and it automatically takes effect throughout the world. But nonetheless, there is a greater view, at least to date, under the Defend Trade Secrets Act, that, as was said in the legislative history enacting it, misappropriation anywhere can hurt the trade secret owner wherever that trade secret owner resides. So that's been an important shift.
Thanks. So, John, maybe you could reflect on how the legal environment has changed and its efficiency, and maybe some of the things you observed, even persuading the government to use national security remedies.
Sure, thanks. Well, first of all, I think the Defend Trade Secrets Act was a big step forward. I think it was important just obviously for moving into the federal level, but I think also just recognizing the overall issue. I think it helped really bring a lot of attention to as I noted earlier, what was a really important issue for our industry. So I think that was a positive step forward. As I think about sort of the challenges going forward, I really see two. One is the international piece. And for many, and you touched on this, Victoria, trade secrets are a really foreign concept, overseas. Many people just see that as developing a country, an economy. The borrowing has gone on forever, and they just see it as building off of something else someone else has already built or done something like that. So there is a lot of work, I think, that has to happen overseas. I do think countries like China are in earnest trying to deal with these issues because they understand that they have to. But it is a very foreign concept, and it takes them a long time to come along. So I think one challenge and one area that needs to be dealt with is the international aspect of this, particularly as you look at an industry, again, like ours that is so global, but it's not just ours, biotech, pharma in general, a lot of these areas that you're having, technology and ideas are moving all over the world. I think the second issue, and this is the issue that we really faced with the Micron case, is that once the trade secret's gone, it's gone. And how do you deal with that? In an industry like ours, where things are moving so quickly and capacity can come online, once that technology is gone and you have a state-sponsored actor or something like that is able to bring in tons of capital, it wipes out the market. And there's not enough time to wait for the courts to deal with it. And so that's the challenge we faced when we were at Micron, and ultimately had to have the U.S. government sort of engage more actively in that to try to shut down the activity and allowing the courts to catch up. So this becomes, I think, the big challenge, and I don't know that we have an answer to that question at all. But once this is gone, how do you seize the activity or cease the activity in order for there to be really, the facts to come to bear and some sort of, restitution be made in that case overall. So I think that is ultimately, that was why we had to, engage the national security level. Intellectual property is a national security issue, is increasingly being viewed as such. And so, that was our solution in that situation. But there is no real mechanism currently to deal with some of these issues, so.
Thanks. Nicola?
So I was asked to speak from the European perspective with the caveat that I am not a lawyer, so sort of broad, generalized
And no
strokes.
longer part of the EU either.
No longer. So I am a former policymaker. I did work for the UK IPO while it was still part of the EU, and one of my first projects was looking at the EU competencies, which was, Anyway, so I can kind of tell you what the sort of general perception is of the directive, and also comment on a study that I was working on and was published. So the directive, from the UK perspective, was not much of a difference, so the impact might have been fairly minor in many countries because it wasn't a big step. But it was important for harmonization, so it is important, and again, this was mentioned in the first panel this morning, uncertainty. It reduces uncertainty because, by creating some harmonization across the EU, we have a better idea, firms know what's happening, and everyone hates uncertainty. So that's a good thing, and it's done some of that. The implementation appears somewhat spotty, but that's fairly par for the course when it comes to EU directives. So we'll see what actually ends up happening. But again, I don't think from my non-legal perspective, I don't think that it was a huge step change. That's also because criminal sanctions are out with the EU competency, so that is only at the nation level. So member states are able to do the criminalization of trade secret theft if they want to. The one thing I think it has had a big impact on is awareness. So I think firms are a lot more aware of trade secrets, as are policymakers. And the conversation is still ongoing. One of the challenges has been for EU policymaking has been this kind of lack of engagement from firms in the empirical studies. So there's a lot of lobbying going on in terms of anecdotal evidence and saying things like the directive doesn't go far enough, but there's very limited engagement in actually providing evidence and I like evidence-based policy. So that's kind of what's generally going on. I'm going to be slightly cheeky and comment on a EC study. So the study was published yesterday, and I'm one of the co-authors. And the grand title was Study of the Legal Protection of Trade Secrets in the Context of the Data Economy. Just rolls off the tongue. And that was commissioned by the EC, so that's from the newly renamed European Innovation Council and SMEs Executive Agency. So the reason I mention that is, they're still paying attention to trade secrets. The next question is data. So how does the data work with trade secrets? So the question we had was, how can trade secrets enable data sharing? And again, that's the whole discussion we had about Arrow. So we've got the Arrow's paradox, data sharing and trade secrets, can they help? The kind of things we got was the same things we get everywhere. So there's this ongoing problems with firms not actually being necessarily aware of how much trade secrets can help them, but not actually using them because they don't trust them. So the sort of moral of the story there is it's still a really uncertain area. But the fact that the EU is continuing to do more work in this area, and our understanding is they will continue to commission more work in this area, is that we should expect to see further EU policy changes, or at least clarifications.
Thank you. This next question, we're going to consider the benefits and costs of relying on trade secrecy. I think this really does go to the overall conference question of waxing or waning. And so what are the benefits and costs of relying on trade secrecy as opposed to other forms of IP? For example, how does relying on trade secrets affect innovation, collaboration, and employee mobility? Vicki.
Well, so conventional wisdom might say, oh gosh, if you're a startup company and you're deciding between patents and trade secrets, one thing to think about is your out-of-pocket cost for prosecuting a patent is going to be a lot, whereas it's free to protect trade secrets. And whenever I hear that and I'm talking to early stage companies, I say, hold on, the cost of trade secret protection can be substantial and you need to pay it every day. It's not that you pay to get your trade secret registered. Obviously, we don't do that. Rather, you have to exercise eternal vigilance over the entire life cycle of the trade secret. So that's the economic cost. So it may be, you don't have to pay a filing fee. Ideally, you're going to be talking to lawyers and others early and throughout the protection of your trade secrets to make sure that you have contracts in place, that you have procedures in place, that you're not protecting your trade secrets internally, but overlooking the fact that when you're licensing information that can reveal your trade secrets, that you're not protecting it in those contracts, that you're telling employees and those that you're sharing information with, this information is to be protected. So that constant vigilance and fine-tuning procedures as threats become larger over the course of time, that's something that sticks with you the entire time that you're committed to protecting information as a trade secret. But the other costs are not straight out-of-pocket costs, and those may be costs having to do with employee mobility, with your ability to recruit employees from other companies. You mentioned that sometimes there are legitimate acqui-hires that you want to hire people who have particular expertise, and obviously there are perfectly legitimate ways of doing it and less legitimate ways of doing it. So you need to wend yourself through that and consider as well, is there sometimes overprotection of information through the vehicle of saying we're going to lock down anybody who's ever seen this information, and so that you're protecting or prohibiting the movement of employees in an industry who may have very keenly developed skills, not all of which is protectable as a trade secret. And so the potential deadweight drag of overly protective measures to safeguard against the movement of employees who know particular information, as opposed to the very legitimate need to make sure that they're not taking information with them, not just in physical form, but in a way that they will necessarily apply them in their new work. That's an incredibly challenging exercise to navigate, and it has social costs and economic costs as well.
Thanks. And I realized I went a bit off script here because I said that Nicola would lead us and you could all react. I don't know if you had independent thoughts on this, John, or you wanted to hear from Nicola first.
Oh, go ahead.
Oh, right, no, okay. So I'll reverse engineer it then. So kind of the cost and benefits, classic economic approach, right? And the main story here when we talk about cost and benefits is kind of the knowledge flows. So I did discuss some of the disclosure, and Victoria's just picked up on some of these. And the labor mobility as the acquihires are also going to, acquire-hires, excuse me. So the idea in economics is that we want knowledge flows. Knowledge flows are good. They lead to innovation, which leads to economic growth and better lifestyles, et cetera. So when you think about trade secrets, of course, trade secrecy and knowledge flows can, but not always, can be at odds. So sometimes they're enabling knowledge flows, which was the Lemley argument that Victoria mentioned, but sometimes they're actually shutting them down. So I'm going to talk about them at the sort of three levels. So the economy level, so what does that mean for economies? And I'll talk about domestic economies. I'm going to sidestep the international economy discussion. What does that mean between firms? So firms working in collaboration. And what happens within the firm. So we want knowledge flows across all of these different environments because we want innovation, but at the same time, we don't want to compromise that innovation by disclosing it too much and leading to a loss of exclusivity. So at the economy level, we have the idea that trade secrets and the associated protection measures like non-disclosure agreements, non-compete, et cetera, limit knowledge flows. They limit labor mobility. They make it difficult for people to move across from one firm to the other. Hence, we have good strategies like acquiring the whole firm. And we want labor mobility because we want knowledge to flow and we want innovation. One of the concerns that, particularly this is happening also in this happened in the US already and it's happening in the UK, is that in the academic community in particular, the assertion of trade secrecy as a property right over academic researchers is causing a chilling effect. So there's been several concerns, particularly on the Asian American community here, that this is being, that researchers are being scapegoated in part of a wider geopolitical and national security issue, and that this is leading to a chilling effect in research. It also makes it more difficult to hire internationally. So one of the reasons that the U.S. has been so successful is its ability to hire the top talent internationally. I have gone into the international. Sorry, couldn't help myself. Having those trade secret protection that makes it difficult for people to move in, move out, et cetera, can dampen all of that. So there can be a chilling effect if it's too high. But as we started off with, we had the discussion, trade secrets are really important for enabling the innovation, enabling IP, and that knowledge flow, the protection of knowledge when we're actually moving it around, trade secrecy can provide that protection. So as is often the case, the costs and benefits here are a little unclear, and so working that balance is going to be a challenge. So that's at the economy level. It's kind of similar when you get to between firms. So one of the key areas that we have as innovation is firms working together. So firms cooperating in collaborative environments need to be able to share their information. Now, again, same story. On the one hand, the trade secret might mean we don't share it with you because we want to keep it exclusive, or the trade secret means we're able to share it with you because we know it's protected. And that could limit knowledge flows or it could enable it. There's always this challenge, of course, is that when we're looking at other people's IP, we may have a different approach than when it's the firm's IP, right? So there's always this, I'm happy to use your IP, but you might not want to use, but you can't use mine. And that can be a trust issue when you're in a collaborative environment. So again, cost benefit. And then finally, within firms. And this is one where I think we're going to see more research and more discussion about what does it mean when you have trade secrets shutting down and siloing information within a large firm. Clearly a bigger issue for larger firms who have to spend a lot more effort in terms of making sure their knowledge flows are happening appropriately and making sure that innovation is happening and teams are working across departments. So having that information siloed in the name of trade secrecy protection may actually come at the cost of the innovativeness of the firm. and that's a problem. The other problem is that we have several studies demonstrating that employees do not feel trusted if they are told repeatedly that they have to protect trade secrets, that they are not allowed to have access. Sorry, if they had, it's a bit of a, it goes both ways. If they feel like they're protecting something, they may feel enabled. If they feel like they cannot access the information that they need to do their jobs, they will feel mistrusted. And that can reduce innovation because, of course, that's not good for a company culture if people don't don't feel trusted. And there's also this tension with investment employee skills. So firms who know they can protect their trade secrets are more happy to invest in the skills development of their employees, right? Because they know they're protected. But from the employee's perspective, if they know that they are unable to take that knowledge with them, they themselves will invest less energy in developing firm-specific knowledge. So across all three of those, economy, between firms, and within firms, we have this constant battle between the two as whether are trade secrets enabling knowledge flows or are they restricting them?
Thanks. John, your thoughts on costs and benefits?
Yeah, I mean, it's a bit of a challenge because it is the business model for us, for our industry, is the trade secret space. So it's not really a question of cost and benefits for us, overall. I do want to state, by the way, in acqui-hire, it's not just us. Everyone's doing that in our industry. I just want to be clear. But I think that it's... but I do think there is this question around knowledge and what that means for the industry as a whole, and also for economies in a national security perspective. I know that's not the focus of this, but we often like to point out that we can't make an iPhone in the United States, and that doesn't mean we can't assemble it. There is no U.S. company that has the ability to manufacture the part that goes in here, period. No U.S.-based company has that knowledge. And so that is a fundamental problem. Again, as I've talked about, there are no, the U.S. companies can buy the parts to make that, but they don't know how to make the parts work, right? That is the trade secret. That's the secret sauce that makes it work. So TSMC, great partner of ours, is the leader in the space by far. They are many generations ahead of Samsung and Intel in this space. And so when you have everything as a trade secret, when that information is not out there and can't be freely shared, it does limit that knowledge as a whole. So I think that is the challenge in a bigger picture is how do you move that knowledge around overall and how to use that in a positive way. But in terms of our industry, the trade secret, that is the secret sauce, that is the critical element, and it is the business model at the end of the day. So.
Thanks. So I think we're about to head into Q&A. So if you have a question, please step up to the mic. I have a couple specific follow-ups I think that are interesting. So in the policy space in Washington, when we talk about cost benefits of trade secrets, we often hear something, we heard it from the stage today, I've heard it from the stage before, where trade secrets are kind of played as a foil against patents. If you don't protect patents, we'll have to rely on trade secrets. And that's always bad because there's no disclosure, and so we're going to prevent knowledge flows and people, you just don't want to see that, right? It's such a shame. And, maybe, whoever would like to maybe comment on the reality of that. Is that argument as ironclad as it sometimes sounds, where, the trade secrets are such a, bad alternative?
We mentioned we wouldn't have your industry without it, and we've all benefited from it.
Yeah, I mean, I think, I think it's critical to our industry as a whole. It's what the model's been built around. I don't know. I think that it's, they're both important, right, at the end of the day, but.
And perhaps are they complementary in some ways? Nicola, are they?
Yeah, so to say, it's great rhetoric, right? The argument sounds fantastic. The original sort of beginnings of economic analysis of trade secrets put them as substitutes. So it was either trade secret or patent, but they no longer do. So we see them as complements. And every patent starts off as a trade secret. So that it's yeah, they're no longer seen as substitutes. So it.
I think, so I just say one challenge, I mean, I don't know what the time frame is on a patent anymore, but I know it's a while, right? And just our industry, biotech, other ones, are the pace. There's no way that the patent system can keep up, at least in the U.S., with that level of innovation. So that, again, that becomes a fundamental a challenge there. So.
And there may be another paradox which relates to that, which is because a trade secret is a trade secret only so long as it's protected as one, that may incentivize further innovation in the sense of, that some information is going to be out there. Maybe we can't all, and we can't all look at the semiconductors themselves, but we can do a teardown of the iPhone, and we can better understand how it works. And so there needs to be continued innovation to keep ahead as knowledge is being disseminated.
Thanks. We'll start with the Q&A on this side. Thanks.
Okay. Good. Okay. My name is Philip Rogers. I'm a PhD candidate at UC Berkeley. So an observation, if I were to make one based on synthesizing all of your statements here. If trade secrets are actually waxing, a lot of it has structural factors, right? So they're faster moving industries. There's geopolitics involved. There's complicated supply chains, so on and so forth. National security and us versus them, theft and all that sort of a thing. So if it's the case that we've got all these structural factors moving toward a waxing, I guess the waxing-waning metaphor baked in says it is in fact cyclical. So are there any structural factors that might lead to a waning, and what, if any, possibility do you foresee of those factors coming to fruition?
Thanks. Vicki, I think you noted that there's some ways, you noted to me recently, there's some ways in which, trade secret, there is pushback.
Well, there certainly is a focus on what limitations may be appropriate to trade secrets. Partly stemming from the fact that a trade secret, before you're litigating it, is a rather squishy concept, and it's unclear exactly what's being claimed as the trade secret. And so certainly in federal litigation in the United States, you're seeing increased attention to, let's define exactly what you're claiming that trade secret to be. Now, is that limiting the trade secret, or is it simply better specifying what was always thought to be the trade secret? Well, I suppose that depends on the organization, but there's certainly a much more acute focus on, not so fast. I know you've come up with cool stuff, but what's the part that you claim to be secret?
All right. Any other thoughts? Yeah, John?
I think it's a great question. I mean, I don't, I think a lot of it is sort of the nature of where we are and the speed of the innovation. I think one thing is if there were a dramatic change of the patent system, I'm not arguing that, by the way, at all. I'm just saying if that were to change and things were to move quicker, there may be more in transitioning to that. But a lot of the factors, the speed of technology, the geopolitical aspects, I don't see that changing anytime soon. And so it's hard to imagine the environment changing. But yeah, I think it's a pretty interesting question.
So I'm aware that some of the legal scholars are arguing here that it's waning for precisely what Victoria said. My understanding, though, in the EU is it's just starting to wax, so we'll see.
All right. So, okay, thanks. Sir.
Rick Neifeld, Neifeld IP Law, PLLC. That means I'm a solo, single, just me. So, Jonathan, I found some sort of paradoxes in your discussion and factual statements. You said that, I believe it's the Taiwan Semiconductor Manufacturer Company, they're, generations ahead of you in terms of manufacturing technology. Is that correct?
Intel, but yeah, not us. So they manufacture for us, but yeah, TSMC does.
So
yeah.
whose generation's that? Is it the Taiwan Manufacturing Company or
Yes.
Intel? Yeah, okay.
Yeah.
Right. So, and they're in Taiwan, which has an arguable political status. And you can't manufacture those things without them, pretty much, right?
Correct.
So if they decide they don't want to deal with you anymore, that's a big problem. That's sort of an observation. Now, under the questions, you you mentioned that you have engineers in many places around the world, different countries, obviously. And you mentioned that you do innovation. I'm kind of confused by how you're innovating when you're just providing design specs to the manufacturing company. If the innovations are in the design, you're giving them the designs, obviously under contract and secrecy, but they have the design specs, all right? They're the ones doing the manufacturing. So what is it that you're protecting by not patenting things? I mean, it doesn't seem like you have in that context, your designs are your designs patentable because they're novel and not obvious? Is that what you are not patenting?
Yeah, I mean, I think I didn't want to get too far into what we do in our business model and how it works.
Before you answer, let me just give you
Yeah.
the big picture. So we have export control, technical data export
Right.
controllers in the U.S. You've got the same thing in the U.K. and several other countries around the world. All the big countries have similar laws. So your engineers that come up with an innovation here that's secret, you can't take that to Singapore to get it manufactured, or Taiwan. So in the sense that you're making an innovation, you can't export it unless you get a license, right? And then if you're going to patent something, you have to disclose the best mode under the US law. And I'm wondering, and if you decide to patent something, obviously you've got some trade-off to play on internally, and I'm sure you do that for some subset of your innovations. How do you internally, as a company, functionally manage those? Okay, we don't manufacture, those guys are at risk in Taiwan and being taken over by China at some point in the next 20 years. We can't export our technical data unless we get a license from the government. I don't know whether that's going to happen, and we'd have to do that. And every other engineering department of our company in other countries has to do that before they ship the information crossways to do improved designs or manufacturing. And some of these things we might want to patent because, that's better than the traits. So how do you functionally manage those internal decisions and processes? What are the limitations? What are the drawbacks? What are the benefits of your system?
Yeah, I think two comments to start. One, this is why I have a lot less hair in this industry than when I started. The second one is I think we could have a whole panel or a whole conference on this discussion overall. Let me just back up by saying, I super oversimplified the way the manufacturing model works at the end of the day. We don't just send a PDF file to TSMC and say, make this. Right? We have 700 engineers in Taiwan working very closely with TSMC. In the manufacturing process, there's two critical pieces. There's that design, and then there's the process technology on how you manufacture. So you look at a company like an Intel or a Micron, they're what's called an integrated design and manufacturing firm. So they do both the design and the manufacturing. So they develop both the process technology and the manufacturing technology. With the rise of TSMC, they're able to spread those costs out on the process development. So we start working on a chip. Again, this is still a super simple oversimplification, but we start working on a chip design. We then partner with a TSMC who's developed a 3 nanometer or a 5 nanometer or whatever process technology. They bring that and they say, hey, here we can make money making a chip using this process technology. But then the process they work on our chips is different than the process they're using for Apple and making Apple's chips or NVIDIA's and their chips. That's where the trade secret comes in. So we're actively involved in the manufacturing, right? So the design is one piece. The second piece is is that process technology and that development. So it's customized, if you will, in terms of how that works. So again, on the design side of things, could you patent that design? Potentially. In some cases, we do that, right? We have patented we have a Zen architecture, for example. We have patented those designs. Those are out there and in the public record because anyone can reverse engineer them. They can take an electron microscope and they can look at that and they can see how that chip works. They can't figure out how to make it from reverse engineering it, right? Because, again, there's thousands of process steps in there. Some of those are sacrificial. You put a layer of something on, then you take it off, and then you do other things in the processing overall. But that's where it comes in, and so there's a trade secret development in there. So there's our knowledge and there's TSMC's knowledge that
How
comes
do you
together.
deal with the best mode requirement?
What's that?
how do you deal with the best mode requirement? You've patented the
Well,
design
let's
architecture.
not go
Yeah.
there.
Yeah.
That's a little detailed.
Yeah.
Yeah.
So, but anyway, so I think these are all large challenges at the end of the day in terms of how you deal with this overall. So,
Yep.
Thanks. So it's interesting what John describes is very deeply, deep, complicated relationships of cooperation. And it tends to show that there's the difference between know-how and what a patented invention. A patented invention is very incremental. It's an increment of what's novel, useful, non-obvious, et cetera. Well, know-how is the whole body of information about how to do something, what you need to do, and John described that in the semiconductor industry. I talked to in my research recently. I talked to the leading vaccine manufacturers during the COVID crisis, and it was fascinating to learn about how, for example, Pfizer, in order to work with its manufacturing partners, to help set up manufacturing with a partner, took 8 months. It took the transfer of tens of thousands of pages of confidential information, but that also took sending a team of 20 people on site to work side by side with their partner, transferring the knowledge over the course of many months. And it shows in some sense that we're dealing with something that's often fundamentally different, which is why Vicky said, and I've said myself too, that the Coca-Cola example, it's everybody's favorite cliche trade secret example. In many ways, it's a terrible example. It's a very mature recipe. It's an end product. It's not a body of information that has to be taught to a partner. But these teaching situations where this cooperation occurs is often exactly where trade secrecy, as Nicola says, fills in the gaps and it enables that kind of cooperative effort to occur. Let's see, sir, you're next.
Alex Raskovich, Global Antitrust Institute. So I wanted to ask a question about the substitutes versus complements versus possibly independent relationship between trade secrets and patents. What you just described, Professor Schultz, suggests that maybe trade secrets are associated with know-how that can't be distilled simply to something that's patentable, versus the patent is something that can be distilled in that simple way, which suggests that maybe the two are sort of distinct and independent. My question is also with respect to waxing versus waning. If patents are on the wane, but patents and trade secrets are complements, that would seem to suggest that maybe trade secrets should be on the wane as well. Whereas if they're substitutes, maybe it goes the other way. So any thoughts on that?
To some extent, it depends on what specific information you're talking about, because there's some information that, once your product's out there, it's not a trade secret anymore. Everyone can see the interesting thing about how it was constructed internally. Whereas if we look at one of your semiconductors, we can't figure out how it was processed. So in one case, if the product is out there and the configuration couldn't have been patented, then there's not going to be either patent or trade secret protection. But it's going to depend very much on what specific information you're talking about.
So the first question you said was about whether the know-how is independent. So are we talking about complement or substitute? And I have a slightly lazy answer in that the economic definition doesn't allow for another option. So we have, when we talk about substitute or complement, we're talking about within an innovation. And so it's not independent if we're thinking about the innovation as in what is patented, what is the know-how associated with that. And so it's a complement or a substitute within it. So it's a lazy answer on that one. Your second point is actually a good point in that saying, I think it's a nuance that is lost when you say it's a substitute or a complement, right? So you're saying if patents are waning, then shouldn't trade secrets. I guess they're both substitute and complement, just to be really annoying. So previously, it was a pure substitute. So it was, it was binary, and that's not helpful because clearly it's not. So we've moved more to a complement, but at the margins, does one increase a little bit and the other one decrease? Well, yes, probably there is some substitution effect, but overall we think about them as complements. So slightly reverting to type answer on that one, but thank you for that point.
Sometimes I've thought about I've looked at in research, at the national level, comparing countries, and I would tend to think, a country that had a completely ineffective patent system is unlikely to have much R&D going on, and thus, yes, trade secrets also waning because nobody's concerned about protecting their R&D with the trade secrets because it's not going to result in a protectable invention ultimately. They may also sometimes, but in the way that you described, yes, if people, for at least for some types of inventions, if there's no payoff at the end, they may not be doing the R&D that the trade secrets are relying. But of course, in other instances, that may be all they have. If they can't rely on the patent system, then they are leaning heavily on trade secrecy. It just, it's like Nicola says, it depends. It's a very complicated relationship. Sir?
Hello, yes. George, researcher in the technology transfer area. I have a question. It relates to both patents and trade secrets and possibly provisional patent procedures in the technology transfer type of practice at a university, an academic and research university. Here's sort of the statement of a problem, and want to get your feedback how to solve this problem. Researcher at the research university makes a discovery, an invention, takes it to their technology transfer office. The technology transfer office receives hundreds of submissions every year. They have to eliminate which ones they want to pursue, which ones are worthwhile pursuing full patent protection, and other sort of limited procedures before that. They have to determine if this new invention disclosure is commercially viable enough. They have to make an estimate. Is it commercially viable enough? Their office really has some capability, not enough capability for all the submissions that they deem are sufficient to go forward. And they have to consult outside experts. While they could consult inside their own university, say at the business school, they go to outside experts, such as at a venture capital firm, and get their idea. Here's our invention disclosure. Does your venture capital firm think this idea is, what will it be worth in dollar cents? So they can make a determination, should they invest in further full patent protection? Problem with that is that most all venture capital firms I know will not sign NDAs. They will not sign anything that says, even though the Technology Transfer Office is trying to work in a trade secret kind of environment before they file a patent, outsiders will not really recognize their trade secret as such, or at least not legally in an NDA. But they do need to get that expert advice, expert financial investment advice on a speculative type of investment in future procedures, investments for this invention disclosure. How can you resolve this kind of problem? The problem is that they need to get this expert kind of advice. They can't get it in-house very well. They have to go outside. The outside type of venture capital people who could provide the advice won't sign NDAs. This is trying to be handled as a trade secret so that in future a patent can be acquired or invested in by the Technology Transfer Office in the research university. So they have a conflict there. Well, how can you resolve this conflict adequately? What's the best practice for doing this nowadays?
Well, this is a recurring issue, and partly it has to do with doing due diligence on the VC that you're sharing the information with, and there are some who actually do have a reputation and have been in lawsuits where the claim is they've been fast and loose. On the other hand, it's interesting, some of our investor clients have said they're going to want to be very careful what they sign, but actually they give good marks to an organization that requests protections because they know that organization is not sharing its information willy-nilly with others. And so I think it usually goes to the question of the level of detail of what's being disclosed. Obviously, the investor is probably looking at a number of potential targets in the same space, and they don't want to be foreclosed,
Right.
and they don't want to be told, oh, you invested in this one because you saw mine, and maybe you're slipping them
Right,
information.
there's legal problems there.
Sure. But sometimes investors are not operational companies, and so sometimes they may not want restrictions on their ability to use in terms of deciding whether to do an investment or how to price it. But they may be willing to sign agreements that they're not going to disclose the information to an operating company. So it's a problem to be worked through. It's a well-recognized problem, and it's not always an intractable one.
As sort of the second part of the question, the provisional patent kind of opportunity as a way of solving that problem. It would seem to me provisional patents, one of the reasons why they were implemented is to try to address this kind of problem, whereby there's an easy, quick, and low expense type of way of at least provisionally protecting your invention disclosure for 1 year while you're doing this investigation of financial viability. Mm-hmm. How can provisional patenting procedures best be implemented in a tech transfer office at a research university, and what are sort of the best practices in those areas?
So
That might be,
That's
may
a
just
pretty-
be beyond the scope
Yeah.
of
Okay.
expertise of the
Stump the
panel.
experts.
but
Yeah.
happy to chat some offline. But
Thank you.
yeah.
So, sir, I think you get the last question.
I just want to offer some insight. I have an unusual background. I used to work for the Environmental Protection Agency. There's a law called the Toxic Substance Control Act. Anytime you manufacture a chemical in the United States, before you start doing it, you have to submit a pre-manufacture data sheet. In my time reviewing these chemicals, only about 3% of those chemicals were covered by patents. All the rest were covered by trade secrets. Thousands and thousands of chemicals. The way chemistry works, you manufacture a chemical through various steps. That's the secret sauce. That tells you how to get from point A to point Z. As long as you protect those intermediate compounds, nobody knows how to get to that final product, commercial product. It's a massive operation. The only reason why I saw all this trade secret stuff is that act has criminal penalties for disclosing the information. But it's a massive operation, and it's been going on for, I don't know, it probably goes back to the 50s or 60s. But that's an area you should really think about. I don't know if you've thought about how much trade secret is used in the chemical industry. It's massive.
Certainly, yeah. I've talked to the National Chemistry Council on this very topic. It's very near and dear to their heart, as you can imagine.
Yeah.
Yeah. So and indeed, it's a related challenge we all face. That balancing the need for regulatory disclosure with trade secrecy. Mm-hmm. And it's an interesting challenge because increasingly, some advocate that, you know, the public interest demands that the public say no what's in fracking materials. And so far, the answer has been no, but the state or federal regulatory agency needs to know. And then they're protected by these kind of criminal type of, you know, sanctions that would be imposed on employees who disclosed. But internationally, it's often quite an issue that there's often a strong suspicion or really knowledge among these companies that what they disclose to the regulatory authority goes to domestic champions. So yeah, this is an ongoing tension, which is why, yeah, within industries that have to disclose quite a bit, they have ongoing dialogues and best practices about regulatory disclosure and how to manage it. And it's likely a paradigm that we're going to have to consider with respect to algorithms, data, and AI in the future, because, you know, companies increasingly hold this valuable information, but it often has public implications. You know, a classic one recently being you have a number of AI applications that are being used to make parole decisions and other other decisions that affect people's life, liberty, and property. And, you know, when somebody demands to know, why didn't I get parole, or why was I sentenced this long, the answer can't be, well, that's a secret. And so this is an ongoing challenge in this area. So thanks for the insight.
The problem is, it's impossible to get patents on all these intermediates.
Sure, yeah.
It's not financially viable. And I think 2 years ago, I got in an open battle with some people about whether it was an in-use situation as far as patent protection.
Right. So,
And I don't think that ever settled out. I think it just basically was a draw. But,
okay.
you know,
Well, thanks for the insight.
Thank you very much.
Thank you. Well, with that, any last words from the panel? Any concluding remarks or leftover business?
It
Nicola?
depends. Well, you gave me the line already. Sorry, it depends.
Nicola, go ahead.
Sorry, it depends. That's my last line.
It depends. Always the answer for lawyers and economists, apparently. So thank you so much. Let's give our panelists a round of applause.
Sorry.